So first, California said that same-sex marriage was legal. Then the voters decided that there should be a constitutional amendment eliminating that right. Then there was a limited decision in May 2009 where the court held that marriages of same-sex couples performed prior to Proposition 8 were legal. Then a major case came down, 2012, very recently, Perry versus Brown, and it was formerly known as Perry versus Schwarzenegger because it's versus the governor of California, and the governor changed. So I guess Arnold's back to acting, out of governor. In any case, the U.S. Court of Appeals held that Proposition 8 was unconstitutional. The court found that Proposition 8 singled out same-sex couples for unequal treatment by taking away from them the right to marry, a constitutional violation in that it subjected a minority group to the deprivation of an existing right without a legitimate reason. So we first start to get the language about discrimination and knocking down this referendum, okay? It's a great lesson in about federal and states' competing interests as well here, and about legislative referendum versus the court's decisions. It's a great historical lesson. It's a perfect example for those of you who are new lawyers of looking at how law is created in America using referendums, state legislators, federal legislators, and the court system. I mean, it's fascinating from that point of view, plus it involves many people in this country. So, the thing about this now, with this case, is that one of the cases that are pending before the U.S. Supreme Court as we speak, and may be decided Monday or the following Friday, is separate from the 8 petitions having to do with the DOMA, repealing DOMA, and whether they will repeal it narrowly or whether the Supreme Court will declare same-sex marriage as a constitutionally protected group in this country. Separate from that, Proposition 8, this particular case, is before the Supreme Court as well. So if the Supreme Court took just this case, they could decide it narrowly. They could say, well, this is only for California residents, and we uphold the Perry versus Brown decision declaring Proposition 8 unconstitutional, or they can make a broad declaration, okay? So we'll have to wait and see what happens, and maybe I will do a second seminar following the Supreme Court if they rule on these issues. Now let's look at New York. The Marriage Equality Act was passed by the New York legislature in 2011, and it amended New York's domestic relations law to state that no application for a marriage license shall be denied on the ground that the parties are of the same or of a different sex. And this was a striking down of DOMA. Well, we'll get to that with the Windsor case. But concerning the same-sex marriage in New York, there are some details to it, basically, is that the Marriage Equality Act amends the New York State's domestic relations law, known as DRL, to grant same-sex couples the ability into the civil marriage. And it states that no application for a marriage license shall be denied on the ground that the parties are of the same or a different sex. And this is a good example. You can see the details that are involved with other states as well. So basically, in New York, if a couple wants to get married, they apply for a license, okay? And if the couple meets the requirements for a license, then the license will be issued within 60 days, okay? So now this applies to same-sex couples as well, okay? And the question comes, are all towns and city clerks in New York State required to issue marriage licenses to same-sex couples? The answer is yes. If a couple meets the legal qualifications for the issuance of a marriage license, no application for a marriage license may be denied on the ground that the parties are of the same sex. This is similar to interracial couples. Up until 1967, there were 14 states in this country that did not permit interracial marriage. So it was case by case in each state about whether you can apply for a license as an interracial couple. I saw an interesting play last night about interracial love, marriage, called Ms. Julie, that came from South Africa, that dealt with this issue. And it's similar to the same-sex marriage issue in terms of discrimination. In that play, the interracial couple felt compelled to kill themselves. So, because they just didn't see any out and no choice because society would never accept their relationship. And she had gotten pregnant. And it was based on a true story. So basically, these are life and death decisions for people. I was also reading today that there is a new index on the Human Rights Campaign that has analyzed 137 municipalities in 50 states. And they analyzed them in 6 categories concerning discrimination with same-sex issues. So you might want to look at that index. Basically, they looked at 6 categories. They looked at same-sex relationship recognition. They looked at employment discrimination. They looked at state rights. They looked at Social Security benefits, etc., and various other state and local benefits, health insurance. Only 11 municipalities in this country had gold stars, had 100% protection for same-sex couples. The rest had varying levels. Now, in states where there is same-sex marriage, the issue becomes, can a same-sex couple get married in a religious institution? The answer is yes, as long as the person solemnizing the marriage is authorized by law. Each religious institution may decide for itself which marriages it will solemnize. Many churches welcome same-sex couples, others do not. So what we need to look at here is that aside from the law, you also have religious pressure and religious discrimination. So whether you're Christian, Jewish, Buddhist, Muslim, or other religions, if you want a religious ceremony, which heterosexual couples take for granted, the couple also has the pressure of trying to find a religious institution that will accept them. Because many same-sex couples, of course, would like a spiritual ceremony, not just a civil ceremony. And then you get into that issue as well. And currently, there are many churches, temples, some mosques, I think, that will accept same-sex, but many will not. There are also some Unitarian-type religious institutions that have been created to address this need or that have existed in a more open fashion. So this is another entire issue that has to be addressed in terms of the religious issues as well. What's interesting is that even in states where we'll talk about adoption and second-parent adoption and same-sex marriage, I have known people personally who could not get a Y membership as a family because the parents were people of the same sex, even where there's been a second-parent adoption, because they did not recognize them as a family. So it's not just a legal issue or a religious issue. It's also a cultural issue. There's also a lot of problem for youth who are same-sex or bisexual or transgender or may be exploring, not know who they are, but if you're not heterosexual, it does affect the children, significantly. And this needs to be addressed in our society as well. So when we talk about same-sex marriage, we also must talk about same-sex families. And I do have, for those interested, I have pages of articles about the psychological impact of growing up with 2 dads or 2 moms because of cultural discrimination and society pressures, and the different psychological issues that arise, okay? It's nothing to do with fit parenting. It has to do with the discrimination coming from the society, okay? So these issues have to be addressed as well, and many of the bullying cases and teenage suicides have to do with the same-sex or LGBT issues. This extends greatly. Even on the foster care level and adoption issues, which we will get to, it affects same-sex couples. President Obama stated last month in Adoption Month that there are so many children who need loving homes, and yet there are many states that will not permit second-parent adoption by a same-sex parent. They won't even accept different races. So that has to be looked at. There are foster children that cannot get homes, families. Okay. Now we have to look at a case determining striking down DOMA. And this is a very recent case. There are 2 circuits that have cases that have struck down the federal DOMA. The federal courts have declared DOMA unconstitutional. So you have DOMA, Defense of Marriage Act, which has been passed by the federal government, by the House, by the Senate, and signed by President. Then you have federal courts that are striking it down, okay? So basically, the Second Circuit, Boston and New York, those 2 circuits have declared DOMA unconstitutional. And it is those 2 circuits why the Supreme Court may take this issue up. Because when there are circuit courts at the federal level that are declaring a federal law unconstitutional, that's usually when the Supreme Court steps in. So let's look at the Windsor case, which is the most critical, I believe, of the cases because it deals with same-sex as a protected class. In 2012, a New York federal appeals court ruled that gays and same-sex people are a class of people who deserve the same kind of constitutional protection as other victims of discrimination, okay? So this applied to lesbian and gay people and protected as a class. In Windsor, the Second Circuit of the U.S. Circuit Court of Appeals panel struck down the federal law DOMA by applying the standard of heightened scrutiny to same-sex unions and found the law unconstitutional as it violated equal protection. It was the first case striking down DOMA that did it on the basis of heightened scrutiny, that recognized same-sex as a protected class. This is significant to end discrimination in this field. The Windsor case was brought on behalf of a New Yorker who married her partner in 2007. It was 2 women. And they married in Canada, where same-sex marriage is legal. When Ms. Windsor's partner died in 2009, she inherited property. The couple had been together for years. So if a heterosexual couple had been together for years, one would inherit the house they lived in, not even a question. And they would not have to pay the tax. They would be treated as a married couple. Well, because the IRS was not allowed to consider Ms. Windsor a surviving spouse under DOMA, she faced a tax bill approaching $400,000 that she would not have had to pay if her marriage had been recognized by federal law. So if Ms. Windsor had been married by a man, she would not have to pay the $400,000 tax for the inheritance. Because she was married to a woman, and legally married, by the way, she was obligated, pursuant to the IRS, to pay the tax. It was a good case to take to the circuit courts because it's very clear about the discrimination. So then, with the DOMA case and the Windsor case, it was a divided U.S. Court of Appeals for the Second Circuit. And the decision came down October 19, 2012. Well, it was in the October 19, 2012 Law Journal. And the federal law, it held the Second Circuit It was actually decided on the day before, which is October 18th. And it was Windsor versus United States. I'll give you the 12-2335-CV. Very important case in U.S. history that a federal law defining marriage as solely between one man and one woman violates the U.S. Constitution's guarantee of equal protection under the law. The appeal was resolved in 3 weeks after oral argument. Justice Dennis Jacobs and Christopher Droney held that the definition of marriage in Section 3 of the Defense of Marriage Act violates the rights of Edith Windsor because it bars the Internal Revenue Service from recognizing her as the spouse of the late, her partner's name was Thea, her spouse's name was Thea Spire, for purposes of the marriage exemption from the estate tax. It was a 43-page decision, and the case went further than the U.S. District Court for the Southern District. There had been a Southern District case where it was concerning bankruptcy laws, and it was also discriminatory because under the bankruptcy laws, if you're married, you have certain exemptions and certain, you can put your assets together. They can then be protected by bankruptcy law together. But if you're a same-sex couple, you couldn't. So the Southern District of New York struck down that DOMA based on that as well. But it went further than the Southern District. And also, like I said, the First Circuit in Boston also struck down DOMA. But both of those cases did it on a different basis. Both of those cases ruled against DOMA by subjecting the definition to just a rational basis, that there was no rational basis for the law, but it didn't go as far as to hold same-sex people, gay and lesbian people, as a class that needs protection due to a history of discrimination. So the Windsor case is the first case in the country that does that ever in the United States, okay, for same-sex, all right? And that means there's a more exact standard of review. Now, there was a dissent, and the dissent was by Judge Straub, and the dissent argued that if the historical understanding of marriage in the United States was to be changed, I believe it is for the American people to do so. So we get into the old philosophical arguments of legal jurisprudence about whether law should be changed by the courts or by the legislature. And if you look at this internationally, it's very interesting. Places like France, most of their changes in the law have been done by the legislature. In Germany, it's really by the courts. The courts take a very authoritative role. In this country, that's a question for you to answer in a philosophical discussion. I teach family law, and it would be interesting for the class. But since this is more in a lecture format, I would answer the question and say that in this country, we have both. It's really dialectical. We have a lot of social change made in this country by grassroots movements, by legislative change, and certainly, though, by the courts. The courts have been very instrumental, for instance, like in ending segregation. So in this case, we've had all three, right? We've had legislative change on the state level. We've had grassroots movements for change. And now we see that the courts are also stepping in on a very significant basis. Okay? But that's what Judge Straub in the dissent is saying, that it's not for the courts to change this. This has to come from the legislature. But as we know, the court system has gotten involved in the past that when a certain group that we would consider a minority, that's not the majority, this gets into the issue of minority versus majority rights. Basically, when there's a minority group that needs protection, the majority may not protect it. Majorities are protected by legislative action because it's done by a vote, or representatives who are supposed to represent the majorities in their jurisdiction. So if everything was done by the majority, you may never get protection for those in smaller groups, even though it might be just to do so. So Straub had his opinion. He believed this was for legislative change. But certainly we do have examples where the minorities do need to be protected, and the courts have stepped in. I mean, otherwise we would not have had, at least not as early, we would not have had black and white children going to school together if it had not been for the court system, Brown versus Board of Ed. So, but these are the arguments that have went on in the decision. The majority first held that Windsor had standing to sue because we predict that New York, which did not permit same-sex marriage to be licensed until 2011, would nevertheless have recognized her marriage, making Windsor a surviving spouse under New York law. Second, the majority said that Windsor's suit was not foreclosed by the U.S. Supreme Court case of Baker versus Nelson, which Jacob said that held that the use of the traditional definition of marriage for a state's own regulation of marriage status did not violate equal protection. So the issue is going to come up, even if DOMA is struck down. Do states have the right to determine their own definitions of what marriage is? Or if it's discriminatory, then should that be outlawed? What if they decided, that marriage can only be, what if they decided that marriage can be as young as 15? Are there overriding concerns, or 14? So this, you get into the state rights versus federal rights. You get in protecting minorities. But that will be an issue, even if the Supreme Court rules. Can states still define their own definition of marriage, even if DOMA strikes down the federal definition? Finally, the court upheld the result reached in Windsor by Southern District Judge Barbara Jones in June, but not on the same rationale. As I stated before, the standard that was used in Boston and the standard that was used by the Southern District was different. They found that the law failed to pass muster, that there was no rational basis for the law. So the Southern District and the Boston Second Circuit did not protect same-sex people as a protected class. They just found there was no rational basis for the law. The Windsor case goes further. The Second Circuit looked at the history of discrimination against gays and lesbians, their relative lack of political power, and other factors in finding that intermediate scrutiny applies, finding that the law nevertheless does not withstand that review. Spire and Windsor, by the way, was 83 years old when this was decided, and were married in 2007 in Canada. But because of comedy, which we discussed earlier, see, I'm going to keep tying in the earlier terms into the later discussion. Because of comedy, basically, that Canadian marriage was recognized in divorce. Was recognized in New York, okay? So basically, even before New York passed same-sex marriage, or even after, what if they did not get married in New York? What if they were married even in another country that recognizes same-sex marriage? But because New York has the comedy, New York will recognize out-of-state and out-of-country marriages. New York recognized Windsor and her partner, Spire, as married, okay? There are other states that do not have comedy, that do not recognize out-of-state marriages or even international marriages of same-sex couples. And like I said, there are many states that have the ban on recognizing same-sex marriage, okay? And some of them have bans, like Utah, on any type of domestic partnership between same-sex.